always right. It doesn't happen in the like in the AICC or the DPCC. It happens with the leader, namely the chairperson or the prime minister, acting in his capacity as the head of the BJP. He will be consulted. But it's why? Because it is the legislative members who have to accept somebody as a leader. So the decision is given by the party that this is the person who is we choose as the leader. Now you cannot. This is not doesn't happen in the plenary. That's the process. And I will demonstrate that. But your lordship is absolutely right. Because ultimately, who has to work? Somebody within the legislature has to work with the leader. So here, they are the ones who are concerned. So their views will be taken and the party will decide.
Yes.
So therefore, they say, okay, let Uddhav Thackeray decide. We'll accept what you say. That's how it happens.
According to you, the decision in the legislative party meeting would always be on the advice of the party.
Always. That's right. Always. And it's recognized by this court, Manat, in several decisions. So, this is the practice, it's the norm everywhere in every political party.
Leader as well as the whip, both you are saying.
Sorry?
Leader as well as the whip.
That's right. That's right. What happens, I just explain that also. Leadership will decide who the chief whip will be. Leadership will decide who the group leader will be. But the chief will decide, not pursuant to, chief will decide, carry out the instructions of the leader when matters are in the house. There, the leader doesn't come in. Chief will say, we go to the leader and say, look, this is the issue before the house. How do we deal with it? Leader will discuss it with the chief whip. Chief will communicate. That's how parliamentary democracy works.
Yes.
But your lordship is absolutely right. It's a good point that your lordship has pointed out so that I can clarify it. Then let us kindly see 22nd of June. In the backdrop of causing party crossing over and thereby attempting to destabilize the government, and considering the consequential political situation that has been created in the state, an urgent meeting has been arranged on 22nd of June at 5 at Varsha Bungalow, Mount Pleasant Road, to face such situation. Your presence for this meeting is necessary, which please note. The said notice has been forwarded on your email ID registered in the Maharashtra Legislative Assembly. That apart, you have also been informed through social media, WhatsApp and SMS. You cannot remain absent for this meeting unless valid and sufficient reasons in writing is given. If you fail to remain present for the meeting, it will be presumed that you have clear intention to leave membership of Shiv Sena party voluntarily, as a result of which action as provided in the Constitution of India with respect to disqualification of members will be taken against you, note of which is taken. This is communicated to Eknath Shinde by whom? By the whip, by Sunil Prabhu, who represents the party.
So is it a typo at the end of that chief speaker? It should be chief whip.
Yes, it's chief whip, not chief speaker. It must be a translation issue.
Yes, it's. I was reading the Marathi. It's chief whip.
Yes. And then the 22nd June notice is sent, which is PDF 39. In the backdrop of the recent concluded Maharashtra Legislative Council elections held on 20th of June, and in view of the volatile political situation emerging in the state on account of repeated attempts being made to destabilize the government by orchestrating defections within the Shiv Sena and to discuss and draw out a political strategy to address and contain any such exigency, you are urgently called upon to attend the meeting of the Shiv Sena Legislative Party today on 22nd to be held at so-and-so place. Please note that failure to participate in the meeting without providing valid and adequate reasons in writing communicated in advance to the undersigned will result in consequential action against you under the relevant provisions of the Constitution. This notice is being sent on email address provided by the legislatures and registered with the Maharashtra Assembly, along with soft copies being served on SMS and WhatsApp as well. This again is sent by the Chief Whip and Malas.
Pages, what pages?
Next document is page 40, PDF page 40, 22nd of June. says, subject notice of Sena Legislative Party meeting, an emergency meeting has been organized on Wednesday, 22nd June at 5 p.m. at Varsha, whatever, to deal with the situation as there is an attempt to destabilize the government by shifting parties in the background and therefore the political situation created in the state. It is important to note that this meeting requires your presence. Notice has been sent to you by email. You have registered with the Maharashtra Legislative Assembly. In addition to you, then SMS, WhatsApp. It should be noted that if you do not attend, then you are liable. In accordance with the Constitution, action will be taken. This is sent by the Chief Whip, and then this is sent to all these people, and they don't attend. Then your lordships may go straight away.
What is the annexure 10?
Annexure?
Annexure 10, that is the next page of PDF 41?
There's the people who attended and those people who didn't
attend.
That's right. That's what it is. Yes. Now comes the document, which is crucial for this case.
What is that document, Mr.
This is at PDF 51. This communication which I have read was sent to Eknath Shinde by the Chief Whip. Now Eknath Shinde replies to it.
Just 1 second.
Not Eknath Shinde, but Kopri. I see. Oh, that's the constituency.
Sunil Prabhu by Eknath Shinde.
Now, kindly see to Sunil Prabhu this document. Now it says you have misused the authenticate letter of the office of the Shiv Sena Legislative Party. A meeting of 45 MLAs of Shiv Sena Party was held under the chairmanship of Honorable Group Leader Eknath Shinde, and in the said meeting you have been unanimously removed from the post of Chief Speaker of the party. Chief Whip of the party, Shiv Sena MLA Bharat Gogavale has been appointed as the post of Chief Speaker, Chief Whip of the Legislative Assembly. As per letter of 22nd June, Shiv Sena Legislative Party office, despite you having no authority to sign, has sent to me notice which is legally invalid. You have no right to send me the said notice. Therefore, it is not binding upon me to remain present. Now, this act, the fact that you did not attend the meeting, the fact that you wrote this letter, the fact that you appointed the Chief Whip, you 45 people or whoever, whether it's 40 or 45 at the moment, we're not on that you are members of the Legislative Assembly, you have appointed your own Chief Whip, you say that you are no longer the Whip. Is all, there is no, as far as I am concerned, this is per se illegal. This doesn't emanate from the party. He cannot, members of the legislature cannot pass such a resolution, cannot defy the whip, cannot remove the whip. So the 40 odd members sitting in Assam convert themselves into the party and decide to remove everybody. The next document is at page 52. Again, June 22nd, 2022.
52.
Same thing, that you have issued the official letterhead in a meeting of 45 MLAs held under the chairmanship of Group Leader Eknath Shinde. You have been unanimously removed from the position of Chief Whip. So he is acting as a group leader of the members of the legislature. So therefore, let's put it in simple terms. In any assembly, 10 people can get together and remove the Chief Whip. And then they can go to the opposite party and with the numbers game that is going on, they can remove they can actually destabilize the government and and have their own chief minister. This is the outcome if this is upheld to be, if it is held to be valid. If such an exercise is held to be valid, the outcome is that you can remove, an elected government can be removed at any time depending on the arithmetic.
To put it on the flip side, therefore, Mr. Sibal, your contention would be then, if this outcome has to be lawfully achieved of removing the chief whip or the group leader, then what is the course of action to be followed according to you?
You have to go to the party, call a meeting of the party. Call a meeting of the party, or you merge.
Party would mean the national executives, or what would it mean?
You have to call the national executive, the Pratinidhi Sabha, the general body, the Pratinidhi Sabha, not the Karyakarani. That's 13 members. The Pratinidhi Sabha has 262 odd members. But the point is, they have never been to the party.
Of course, the only chink in that submission, I mean, we must put it to you straight so that you can deal with it, is that was not the process which was originally followed when the chief whip or the group leader was nominated, unless we also postulate that when the group leader and the chief whip were originally nominated, Uddhav Thackeray was acting as the party.
Yes, because he was neither a member of the council nor was he the chief minister. He was nothing. He is the Paksh Pramukh under the constitution.
One thing, as Brother Jasemma Shah pointed out very clearly, it's obvious that the appointment and the nomination of the group leader and the chief whip was made at a meeting of the MLAs. Now, because it clearly says Amdarancha Baitaki. But
answer that straight away.
But it is also in the presence of Mr. Thackeray, and the MLAs begin by saying that we are assigning to Mr. Uddhav Thackeray the right to take all decisions.
Right.
Then they pass a resolution at a meeting of the MLAs. So it's a sort of a hybrid situation where the group leader, power to nominate a group leader and the chief whip is delegated to Shri Uddhav Thackeray, but there is a, so to speak, an anointment of them at the meeting of the MLAs. So the only way really that the two can be reconciled is by postulating that in that sense, at the original meeting, Mr. Uddhav Thackeray was the party. He was, whether you like it or not, he was the party. It was not a meeting of the national executive. It was not a meeting of the plenary of the party. But he was really the whole and soul, because he was not an elected member at that point of time at all.
He was the president of the party.
He was the president.
Paksh Pramukh.
He was the Paksh Pramukh.
Yes. Well, it's very interesting your lordship raised this. Let's analyze it. Let's analyze the circumstances against me. Let's assume this all can be done within the legislature. Let's assume that the party has no role. So, therefore, 50 people in the House can actually have a leader in the House without reference to the party. If that logic is accepted. 50 members of the House can actually oust the party whip appointed by the party. That's the consequence.
When were the elections held?
2018.
The first document at page PDF 14.
23rd January 2018.
17th February 2018.
No, but that's the communication, but the elections are 23rd January 2018.
It speaks about that.
Yes. The point that I'm making to your lordships is, this is unheard of in any democracy, in any legislature.
Elections were held on 23/1/18, you say, right?
23.
Yes. But it will be entirely unworkable. Because you will then say that there is no relationship between the members of the legislature and the party. They are independent of the party, they can take whatever decision they like. It will be destructive of, if you ask me, the basic structure of a system of governance which allows the party and the legislatures to be intertwined in matters where the decisions have to be taken on various very significant issues as they come up in the assembly or in parliament.
Well, you can tell me later. But what I want to know this letter speaks about organizational elections.
Yes.
It talks about organizational
That's correct.
elections. So what are this? It is to the different tiers, is it?
Yes, it's in different years.
There is something called a general body, is it?
There is a Rashtriya Karyakarani, which is the national executive, 13 members. Then there is the Pratinidhi Sabha, which is about 262 members.
What is at the bottom?
Sorry?
What is representing the general body?
Pratinidhi Sabha.
Pratinidhi Sabha.
Pratinidhi Sabha. But of course, you can't hold a meeting of all the members of the party all over Maharashtra.
I'm just asking for information.
Yes. So there's a tier system. There's a tier system.
Is at the is virtually like a general body.
Yes. There's a tier system by which people are both appointed and elected. Appointed.
Pratinidhi Sabha.
Yes, Pratinidhi Sabha.
And Mr. Sibyl, possibly this line of argument of yours is also buttressed by 2B of the 10th schedule, which says if he votes or abstains from voting in such house, contrary to the direction issued by the political party to which he belongs, or by any person or authority authorized by it in this behalf.
That's correct.
So the whip is really a person who is authorized by the political party.
That's correct. That's correct. That's how it functions. That's how.
Because the direction has to be given by the political party. It can't keep on giving a direction. It's a larger body.
Yeah, that's right.
So therefore, it delegates its power and it authorizes a person who will then issue a direction on which way to vote in the assembly.
In matter when it came up before the law commission, it will be disastrous for democracy, disastrous for the country if the legislative party is allowed to act independent of the political party.
So the actual whip, without, it says, or by any person or authority authorized by it in the
I read that.
So the party really nominates or authorizes a person.
That's correct.
And the act of defection lies in voting or abstaining from voting contrary to a direction given by the party or that
Because I want to ask myself, supposing there's a bill in parliament, the legislative party on its own can't decide what the position will be.
Right.
It cannot. Naturally, there'll have to be consultation with the party. Because they are not living in a side, they are not acting as a separate entity.
They are really the voice of the party in parliament or the state legislature.
That's correct.
It's the political party.
The genus is the party, they are the species.
Yes.
Yes.
The political party which either sends the MLAs who, because of majority from the government,
yes,
or they could even send members of the legislative assembly who will be sitting in the opposition.
That's correct.
So nevertheless, the controlling factor
has to be
the political party.
Yes.
Which will, through its MLAs, operate either as
because they are there because of the party.
The mandate is the mandate of the party.
That's correct.
And therefore, how they function in the house is determined by the mandate which has brought them into the house.
That's correct. Exactly.
And I think that seems to be a fair understanding of the 10th schedule.
The 10th schedule
has to be linked to it.
Whereas you have to maintain the integrity of the political party within the house, its programs, its views on reservation, its views on the 10th schedule, its views on foreign policy. Individual members of the legislature don't decide on foreign policy issues, the party decides. And party systems are such that you have committees where people who are in the past also, who are members of the party, who have experience in foreign policy, who've been ex-ministers of foreign policy. They become members of the committee, they advise the party as to what position should be taken, and a matter comes up, the legislators are only told that this is what should be done. Within that framework, you can make your case up.
So they articulate the views of the party.
That's correct.
Yeah. One important distinction is... Go ahead. No.
Yeah, you tell them.
Just take 15 seconds, a bizarre example of how the party governs. Very interesting. I happen to be chairman of the Parliamentary Standing Committee in 2011, and the most contentious Lokpal bill came. We had a report signed by all except 3 dissents. 3 dissents are all, every 31-member committee, which is a mini parliament, everybody signed, all political parties, 17 political parties. Matter went to Rajya Sabha. All of them supported the report because they had signed it. Overnight, whether the party stand of one particular party, I'll not name it, changed. Matter came to Lok Sabha. The same party which was signed took a different stand in Lok Sabha because the instruction from the party to the legislative wing of the Lok Sabha was that no, this has to be opposed. Lokpal has to be opposed. This is in the record of Parliament. So when the party decides, this is an extreme example that the party which had agreed with the report actually opposed it in Lok Sabha because the members are only legislators, but they received the instructions. It's an important, well-known regional party, but the policy changed that no, we must oppose Lokpal, therefore it was opposed in Lok Sabha. So that was the validation of this kind of example.
Any number of examples like that. Any number of examples.
The reverse engineering.
It's a political decision of so many factors.
The legislative members controlling the party is actually reverse engineering.
Yes, your logic is right. Exactly. Therefore, these documents become exceptionally important because they determine the outcome of this litigation. If you give validity and legality,
So, Mr. Sibal, we've seen all the documents now.
not yet, Murad.
All right. So because the next step, I was going to request you to formulate it in 2 or 3 submissions for us, but you can complete the documents and then
Yes,
give us a
yes.
reformulation of 2 or 3.
No, but then I have to read your logic some judgments which actually deal with it.
Before we go into the judgments, you can just formulate it for us in
Yes,
2 or 3 submissions.
I
We'll
agree.
take it down, but
I agree.
let's complete the document, then the formulation, and then the judgments.
Yes, let me just quickly go through the documents now.
Yes.
So page 52 I've read. Then kindly come to Murad's resolution of the meeting of the Shiv Sena Maharashtra Legislative Assembly 1990 to 2024. Murad, that document is at page 50, PDF 55. Now, Murad, this is what is passed. Very interesting.
What is the date?
Murad, it is signed by Bharat Gogavale. Very interesting document. This tells you the story, Murad. Resolution of the meeting of the Shiv Sena Legislative Assembly. Maharashtra Legislative Assembly 1990 to 2024. We, the following members of the 14th Maharashtra Legislative Assembly, belonging to the Shiv Sena, we are notified as the members of the Maharashtra Legislative Assembly as members of Shiv Sena Legislature Party. We had unanimously elected Eknath Sambhaji Shinde on 31st October 2019 as group leader of the Shiv Sena Legislature Party. There was a pre-poll alliance between the Bharatiya Janata Party and Shiv Sena Party for the 14th Maharashtra Legislative Assembly. There has been great dissatisfaction prevalent among the members of our party, Shiv Sena, and our party cadre at large on account of corruption in the government administration regarding police posting, corruption by then Home Minister so-and-so, sitting minority minister so-and-so. Apart from above reasons, our party cadre faced tremendous harassment and distress on political as well as personal grounds. From the opposition, ideological parties who are now a part of the government and were using their office and power to undermine the base and foundation of Shiv Sena. There is enormous discontent amongst the cadres of our party, Shiv Sena, for forming the government with the NCP and INC, who are ideologically opposed to our party. There has been a compromise on the principles of our party, Shiv Sena, which has been a party of fierce ideological base and was formed for fighting for the rights of local Marathi people. For the last 2.5 years, our party and its leadership have compromised party principles by aligning with the contrasting ideologies for the sake of achieving power. The ideology of our party leader, late Balasaheb Thackeray, was to give a clean and honest government to the people of Maharashtra, and also without compromising on the principle of Hindutva, which was defeated on the first day itself by aligning with the opposing ideologies. Shiv Sena and Bharatiya Party has forged a pre-poll alliance for 2019 Maharashtra Assembly. They sought the blessings of the voters of the Sena BJP alliance, which the voters accepted and voted in favor of alliance. After results were out, the Shiv Sena severed its ties with the BJP and formed an alliance with the opposing parties, which they had fought against in 2019. This act of our party leaders had a tremendous negative impact upon the voters and the party cadre. There was a continuous hue and cry towards party leadership for the act of aligning with the opposing parties. Ignoring this, party leadership went ahead and formed the Maha Vikas Aghadi government. For the last 2.5 years, we, the Shiv Sena legislative party members, were facing tremendous pressures from the electorate. We, the members of the legislative party, as well as all leaders and workers, throughout the country were facing a lot of humiliating questions. Our leader, Barasaheb Thackeray, was always a strong nationalist. We've also been subjected to a lot of criticism for being part of the corrupt Maharashtra. In view of the above, the members of the Maharashtra Sena Legislative Party have met today and resolved this under. What is they resolved? Hereby resolved and reaffirmed that Shinde, who was appointed as leader of Shiv Sena Legislative Party, is and continues to be the leader of the Shiv Sena Legislative Party of the 14th Maharashtra Legislative Assembly, and this is was proposed and seconded by members of the legislature. And I hereby further resolve that Bharat Gogavle, elected and appointed as Chief Whip of the 14th Maharashtra Legislative Assembly, is cancelled with immediate, and Sunil Prabhu is cancelled with immediate effect, proposed and seconded. Nominally, there is no reference to any meeting of the party. There is no reference to any grievance made prior to this date. They're all members. He was serving as a minister for 2.5 years. There is no reference to any grievance that he ever had. No reference. No reference to any statement he made in any organizational election. No reference. suddenly could not have happened on the 21st of June, Maharaj. This sudden realization that this great injustice has been done, Maharaj. Obviously, this was planned. Maharaj, if anybody had any grievance of this nature, it would be in public statements, it will be in organizational meetings. After all, this is from 2018, we are in 2023 now, Maharaj. Not a single statement anywhere. So obviously, and what this statement is being made from Assam. Why Assam? So it's not something, it's all pre-planned, it's a conspiracy. It's not something that happened overnight. And you're talking about poll promises. Let me talk of history then. The poll promise was broken at the time when Devendra Fadnavis and Ajit Pawar were sworn in the early hours of the morning by the governor. What about that poll promise? So let's not go into politics.
I was just going to say that now you are trenching into
No.
politics.
No, but this is all politics.
You are now leaving the area of constitution.
No. When I said it in the context of the grievance that he has made. He has made a grievance of poll promise.
No, we are not at all, Mr.
Yes.
So,
let's go. That's why I said we are. I'm sorry.
Yeah,
but therefore, Mr. Sibal, ultimately, I mean, we're just sort of pushing your argument to its logical conclusion in constitutional terms.
Yes.
Therefore, what you are saying is that, look, when Eknath Shinde was nominated as a group leader and the whip was then nominated, the whip was also notified. It was at the behest of the party,
Yes.
be it at the MLA's meeting.
Right.
An alteration of that position was made at the meeting which was chaired by Mr. Uddhav Thackeray. The legislators could not have either abstained from the meeting, which was convened by the party president, nor could the legislators have replaced the whip or the group leader.
That's correct.
So that all that they did was really therefore was contrary to law and therefore invited a disqualification under the 10th schedule. All this really then leads us to this, that therefore they have incurred
The disqualification.
they have incurred a disqualification.
That's correct.
Now, having said that, therefore, this is therefore a case where the speaker has to ultimately decide upon the disqualification which they have incurred, isn't it?
Absolutely.
I understand.
That is, Mr. Sibal, that is an area which we are not able to come to a bridge.
I will. Yeah. Yes. Yeah. Yes, I made that argument. Yes. I will try and
Of course, the constitutional position of the speaker to decide.
I tell you also the problems in that area. But the kind of
Just problems in the area, we see that. But
Yeah,
also we understand the significance of the point which you have made, which is a very significant point for constitutional democracy, that ultimately the party is supreme.
yes.
And legislators get there into the House or the Parliament or the Legislative Assembly on the mandate of the party, what the party means to the people.
Correct.
Therefore, you are really elected as a representative of the party. Your behavior must be governed by what the party dictates.
Yes.
And a group of legislators, whether you are 1/3 or 1/10
Doesn't matter.
or even 75%,
That's right.
cannot be really determinative of the wishes of the parties. You can alter that position if the party authorizes you, or
Correct.
you leave the party.
Correct.
So far, so good. I mean, that's a very significant point which you have made. But
I understand.
the
The next
next
point.
point. I mean, what is the consequence?
Yeah, I will. I understand.
Which you are really telling us that, look, the facts stare you in the face. Now, why go to the speaker?
Yes, that's what my summation is. What is it that the speaker is going to do in this?
It could be twofold. One, as you say, well, the speaker himself cannot be trusted as an impartial arbiter.
I withdraw that because we are talking about the constitutional position.
Right. The second would be where the facts are so clear.
Yeah,
Then you take the decision with the speaker ought to have decided that there is only one and one conclusion.
that's right.
That, Mr. Sibal, honestly, that is a matter of disquiet for speaking for myself. I mean, should the court be taking into that? Entering into that area? That's an area of.
Your lordships have been persuaded in the past. I hope to persuade it into the future as well.
There are very serious ramifications. Just as you know the ramifications.
I will address your lordships on that.
The ramifications which you have referred to for constitutional democracy, if individual legislators start bucking the party discipline, There are very serious ramifications if we start taking over these functions.
Dangerous.
No, what happened was, in one particular case, which is the Constitution bench, where they said that this illegality cannot be continued even for a day. So we will take the decision.
Because
They are occupying the post of the minister. This cannot continue even for a day. I will not send it back. We will
right
take
or wrong, this is the system which we have now assumed to ourselves as we the people. And when the courts try and breach the system, it's a very
Manoj, I understand.
that's what is worrying us. I mean, put it to right up.
Quite frankly, a constitutional court should be worried, because if you create this as a precedent, it can happen in other situations as well, and that not be a good precedent. But I am not disputing that. Please, I know the limitations of a constitutional court. I know that, Manoj. But what has happened in this case, unfortunately, is that this has happened because of a judicial order. This would never have happened.
Already, we also go to this extent that, if a situation transpires because of a judicial order, we are not saying that it has.
Yes,
we
I understand.
No argument.
Yes.
And therefore, it's the duty of a court to rectify a situation which emerges as a result of its own order.
That's right.
All right. Various other contexts, we always say
You have said that in several judgments.
minimum gravity.
Yes.
But assuming that is so,
Yeah.
and we place ourselves in the position in which the court was, say, immediately before the 27th,
Yes.
what would the court then have done? That, look, let the speaker decide. Keeping aside the issue of 2-day or 7-day notice.
Yes.
Let the speaker decide.
Yes.
So if we have to restore the position as it would have been, but for that order of the 27th, we would have said, let the speaker decide.
Yes.
Possibly, your argument would be, until the speaker is deciding, no trust vote. Let him take a decision first, and then, because the trust vote.
Because everything held there after that happened because of this order.
But therefore, if you have to restore the situation as it stands immediately before the interim order of this court, we can restore it by saying that, well, the speaker has to take the decision.
Right.
As that date.
Yes.
Had they incurred a disqualification.
Yes.
But it would be very difficult for us to take over that function.
But I don't mind. Let that deputy speaker decide. I have no problem with that. That's what happened.
And therefore, which deputy speaker?
The speaker, who was denied the right to continue with the disqualification. This has happened in the other case.
So then we restore a putative state of affairs.
Yes, your lordships have done that.
Overtaken by events.
In Nambam Remia, your lordships have done exactly that. Exactly that. Because when I argued this before the Constitution bench, then I said, no, what is happening is you let things happen, and then you will tell me later that we can't reverse it. He said, no, we will reverse it.
But then you support Nabam Rebiya's course of action when it suits you. And when Nabam Rebiya is creating a problem, you wanted to...
No, that's because there are two different issues in Nabam Rebiya. I'm sorry, you can't put that argument.
No, we're not at all.
Two different issues. In fact, I was wondering when your lordships are going to decide to refer it to 7, because this is the real problem. Because that's intrinsically at the heart of the matter, which is why I said you take it up as a preliminary submission. Because ultimately this can only be decided.
But Mr. Sibal, look at the consequence. You today have a speaker. You have a speaker in a democratically elected house. Tomorrow you may have a speaker in parliament. And the Supreme Court said, sorry, we are now overriding the mandate of this speaker. We will retrace our steps back to say now something which is 8 months ago, restore a speaker who is now no longer holding the office of the speaker, and we tell you, we now decide that somebody is the speaker.
He's still deputy speaker. He's still deputy speaker.
And ask that speaker or deputy speaker to take the consequence. I mean,
he's still deputy speaker. All right. One second. Hold on. You got a lot of hurdles to cross. But anyway, let me.
You're all very seasoned constitutional laws, but you know what is worrying us.
No, I'm not going to.
What is worrying us?
Make a proposition that will in fact destroy the fabric of a constitutional structure that has been in place since independence, since we were a republic. I'm not going to do that. But see what has happened. First of all, the no stays. They are given time till 12th July. But more important, on the 29th, this court says that we will set aside everything that happens thereafter. Similar is where we are now. We say, please stay everything. Don't allow the trust vote to happen. Decide this matter. It could have been decided on the 12th of July. Then the court tells us, no, doesn't matter. On the 29th, all that is subject. Now your lordships are telling me, how can it be subject? Now your lordships are telling me, rightly maybe, that how can we go back on 27th? Well, that's exactly because of the two court orders. What do we do?
The court order was also prompted by what your speaker did.
I said, you see, don't allow them to take the vote. Don't have a trust vote. We said that. Then on 29th June, that order is passed. Thereafter, all matters are placed.
Had your speaker chosen to follow the law by giving them 7 days?
No, but the law is never review. But the law is follow on.
The court would have said, all right, go and respond to them.
Law is follow on. But I tell your lordship now, I can't in hindsight say what the court should have done was state everything, allow them to file a reply, and allow after 12th of June for the speaker to decide. What is the problem? There was no problem. But the status quo changed. Well, they were given time till 12th of July. All right, let them give time. Despite the fact that it is contrary to follow on, forget it. They should have been given time. They should have filed a reply. The deputy speaker would have decided. Why allow the status quo to be changed? And that also, because the judicial order says, doesn't matter, even if the status quo is changed, we'll restore it back. So we had two judicial orders then. And now your lordship rightly puts now under the proceedings of the House, a new speaker has been appointed. But then you yourself said that we will deal with it. All that will be subject to.
So essentially, we'll therefore have to invalidate the trust vote which took place on the.
Because it was only on the basis of these 39.
A trust vote which we will have to invalidate a trust vote which never took place. So
no. Even the trust vote that took place on 4th is subject to. I'm sorry. All other actions are subject.
My learned brother,
I'm sorry.
Huge challenge. just what
Yes.
on your submission that as per the interim order dated 29 June, that all subsequent proceedings are subject to ultimate.
Yes, yes.
Now see, actually we have to consider that on 29 you challenge the trust vote to be held on 30th June.
Yes.
Correct. You challenge that only.
That's correct. That's correct.
Correct. Now see the order, interim order which is passed by this court on 29.
Right.
See, please read it.
Yes, I agree. Also, an order compilation. Well, let's see that.
That is it's in on page
Page 7 of the order compilation. Volume
Orders compilation, volume 1.
volume 1.
Yes, I have it. PDF pages 7.
Order dated 29 June.
It starts. We'll just see, Malas.
PDF it at 10. Right. Operator.
I'll just read it.
Yes. This is the PDF.
Yes. Page, Malas, the writ petition is ordered to be listed for hearing.
Para straight away you.
Right, having given our thoughtful consideration. That's the one?
Yeah.
Yes, yes. We do not find any ground to stay convening of the special session of the Maharashtra Vidhan Sabha tomorrow at 11 a.m. with the only agenda of a trust vote. Proceedings of the trust vote to be convened on 30th shall be subject to the final outcome of the instant writ petition as well as the writ petitions referred to above.
Correct.
Yes, and the special session of the Maharashtra Vidhan Sabha shall be conducted. So as well as writ petitions referred to above.
Okay, but what
Writ petitions referred to above is that
what was the subject to ultimate outcome? The proceedings of the convening the meeting on 30th would
I agree.
not all the subject.
Well, I don't dispute that. I'm saying
The fact remains that on 30th June for whatever reason
I had resigned earlier.
the
Your Lordship is right.
set on
Your Lordship is absolutely right. But unless my
your submission that all other as per the order dated 30th June, all other subsequent will be
unless I just asked myself a simple question: had I not resigned, that trust vote would have happened, and I would have the same thing would have happened. Correct. The same thing happened on the 4th. The same thing happened on the 4th.
Provided the meeting would have been convened on 30th.
But the same thing happened on the 4th. The trust vote was happened on the 4th. And that is also subject to writ petition was filed. Your Lordship said we will consider that that will also be subject to.
No, we were on your submission.
Lordship is right. I mean, technically, what my Lord is saying is absolutely right. I cannot have any two opinions. There can be no two opinions. But the fact is, in substance, it's the same thing. Whereas, yes, your Lordship is right. I mean, I can't get away from the fact that he said, what's the point of going to these people are going to vote for him. That's exactly what happened on the 4th. That's why we challenged the 4th. That's also the writ petition is here. So, are we going into the technicality or are we going into the substance of the matter? Whether these 39 could have voted in favor despite the whip. There is a whip issued, Maharaj, on the 3rd. Whip is issued on the 3rd that you vote against the trust vote. They did not. And who is the whip? Sunil Prabhu. Voted against the whip. So, where does it take us? It doesn't take us anywhere. So, he votes against the whip, and Gogavale is then appointed. He can't be appointed by the Speaker. And Gogavale, they have issued, Speaker has issued notice to us. Those notices can't be issued. I can't be subject to any disqualification proceedings. And my notice has been given by the Speaker to me to be disqualified. Your Lordship will strike it down on the facts. So all these issues will have to be decided, Mullah. I'm sorry.
Which are the issues that you want us to decide?
That's exactly what I just showed. Let's give it to my Lord. No, let's give it. I'm sorry, Mullah, this is taken.
Responded yet.
Mullah, they will have. Through what your lordships
That crucial
might or might not wish to decide.
the crucial facts which you have
It's not finished yet.
told us, leading to the 22nd.
Yes.
I think those are completed, right?
Yes, those are completed. Then what happens thereafter? Another letter is the letter of 22nd.
To the notices on the 10th schedule notice.
That's correct. That's correct. And thereafter on 24th, another notice. Then on 25th.
We are aware.
Mr. Sibyl, we were at page 55 of that.
You want me to finish that first?
So that that part is over just for the sake of completeness.
All right, we'll do that.
Indicate those dates. And
Yes, we'll do that.
Let's go to page 55. We were at page.
Let's go back to my document. The convenience compilation.
Two, right? Convenience compilation. Two.
We are at 49. Now this is that PDF 62. This is that document which your lordship have already read. Dated 22nd, dated 21st, but served on 22nd at 11:30. Which your lordship have already read.
This is the important.
Let's make a note of it since we are.
That's right. I'm not going to read.
Relevant for number.
Page 62, right?
Except the fact that they are the majority, no other cause was shown. So 179C, I made my summation on 197C already. So, and that this is connected with Navam Redia, this document. So that issue is over. Then kindly come to the page, PDF 71. This only gives you what is happening. 40 members from MLAs in Assam. No dispute on any of this.
Then next.
And then is the disqualification petition filed on the 25th.
Page 62.
That's at page 72.
Mr. Sibyl, page 62 PDF that we've just touched upon. Notice to move a resolution. What does para 2 say?
At page 62.
Yes, please.
Yes, I just. Para 2 says, we all respectfully submit that you no longer have the right to continue as Deputy Speaker, as you no longer enjoy the support of the majority of the House.
The House.
More particularly the following members of our party.
Majority of the House.
Yes.
Is it what you're trying to? This is your emphasis.
Yes.
That here,
yes.
Also the references to the majority of
in
the House. And goes on to say particularly the following members of the party.
That's correct. Because what does party mean? The legislature party.
No, that's not quite correct. But my learned friend repeatedly says this. But every member of the Legislative Assembly and of Parliament is ex officio.
Yes, yes.
Member of the Prathinidhi Sabha.
That's correct.
We are also part of that.
That's right. No doubt. Hold on.
There is
no dispute. The 39 members of the legislative party are also members of the party.
No dispute, no question about it.
No, how am I not said anything?
They have to have primary membership.
Yes. I have not said anything against that. The only thing is that 39 members can't hijack the party.
That's all.
That we'll see. That's the issue. Of course, we welcome you. It's all right. No, let's definitely continue, please.
Next.
So, your ladyship was right. Exactly, Then kindly come to
59.
59.
PDF 72.
No, first, yes, 71. PDF 71, page 58. Maha trouble for Uddhav. Hemanta meets Eknath, 40 MLAs in Assam.
Sorry, where are you? The Hindustan Times article.
News. Hindustan Times article.
That's to show that it's reported.
It just shows, that, the surroundings are comfortable.
Relevant for 10th schedule, no doubt. Not for a speaker. Relevant.
Then, the notices.
inference.
Now, this is the notices we don't have. No more documents. All kinds of statements have been made, that we are following a separate party, but that's all happens in Assam. It's a given, so let's not go into that. So this is all, as far as the documentation is concerned. Now let's see, what the issues are. The first, deals with Nabam area, basically, so that the lordships will have to decide. That is, does the Constitution permit an institutional hiatus by tying the hands of the Speaker in functioning under the 10th schedule through proceedings initiated by a member of the Legislative Assembly under 179C? Right? I've argued that your lordships will decide. All I can say in that regard is that if you allow that law to stay, it will be misused. It will be a new model of toppling governments. Safety valve defectors. Now, the second, what are the consequences in law when members, whether in minority or majority, of the legislative party in the House act dehorse the political party and are contrary to the directions of the political party and assert their separate identity by forming a separate group within the legislative party in the legislature? Squarely, that's an issue. Squarely. That can, in any legislature, X number of people form a separate identity and say, we'll not listen to the party, we'll decide what to do.
That you've been arguing yesterday.
Will a group within the legislature party asserting their separate identity and acting dehorse the political party or contrary to its directions have per se incurred disqualification under para 2 of the 10th schedule? There's no evidence to be led here. Admittedly, there is a whip, Sunil Prabhu, on the 3rd, saying vote against the trust vote. Admittedly, on the record of the House, they voted in favor of the trust vote. Even by that time, Gogavale would not have been appointed by the Speaker. The Speaker has no right to appoint Gogavale. He appointed Gogavale on the 3rd evening, which he can't do otherwise, but that's another matter. So, what is there for the Speaker to decide? There's a violation. The vote is on the record. You're not usurping anything. You're only declaring.
This question is incoherent. This issue is incoherent. What is the logical follow-up? Then the Speaker will say it's per se case.
I'm sorry?
Speaker will say it's a per se case.
I hope so.
You are.
I hope so, I hope so.
Matter. What you're trying to say in 3 is, in per se cases,
yes,
should the court not decide?
Yes, that's the point. That's why I put per se there, only for that reason.
God.
We have to ultimately persuade you, so we have to. I always say, without the court on your side, there's no point arguing. And the only way to have the court on your side is to be as reasonable as possible. The politics is essentially unreasonable. The art of politics is to make the unreasonable look reasonable.
Necessarily. Politics can be very reasonable also.
3. Will a group within the legislature party asserting their separate identity and acting dehorse the political party or contrary to its directions have per se incurred disqualification under paragraph 2? Then 4. Can a group within the legislature party asserting their separate identity and acting dehorse the political party or contrary to its directions have the constitutional authority to alter the leadership of the political party in the House or the whip appointed by the political party in the House? Directly in issue. Because of those documents, as I've shown to your lordships already, that you are removed from Assam, you are removed as the chief whip, and I continue to be the party, and you are removed as leader. I continue to be the group leader. 5. Given that an elected government should be allowed to serve its full term, this is now a constitutional premise on the basis of which I made this proposition. Given that an elected government should be allowed to serve its full term as a matter of constitutional law, can a group within the legislative party asserting a separate identity dislodge an elected government while proceedings for disqualification under the 10th schedule are pending, that is, before the Speaker decides on the issue of disqualification? Directly an issue. But what you are doing in this process is sidetracking the disqualification proceedings, toppling a government, and then saying, no, my Speaker will decide. Actually, the constitutional premise and every constitutional authority should in fact help in ensuring that an elected government continues to be in power. Well, something that I'm going to argue later, but I want to just tell your Lordship something very interesting. Well, as the governor is to decide to administer the oath of office. So 30 people go to him, 20 people go to him. The governor must first know which party they belong to. Either it's a post-poll alliance or a pre-poll alliance. Right? So the governor must first ask them, which is that party? Now, their position, 39 members' position is inchoate. They can't represent the Sena. This is the first time this issue has arisen in this country. So, how does the governor decide that I'll administer oath of office? There is no party before it. Discussing this is an issue that your Lordships will have to consider. So, let's come to 6. Should the governor, who is constitutionally obliged to sustain the continuity of an elected government, change the status quo by allowing for a change in government before disqualification proceedings are decided by the Speaker? Then next, whether the governor can swear in as Chief Minister a person against whom a notice for disqualification has been issued by the Speaker acting as a tribunal under the 10th schedule and is pending adjudication. What is the impact of pending disqualification petitions on the ability of members to participate in a test of strength on the floor of the House when their vote would have the effect of toppling the government? I can understand in a situation that clearly doesn't matter, the outcome would be the same. But here the hard facts are, their vote topples the government. So you have allegedly, according to me, a member who should be disqualified, voting to topple an elected government without the governor asking him which party you belong to. Without the governor even finding out for himself. Or the governor saying, look, there are some disqualification petitions, by this an elected government to be toppled, let's stay our hands, we will not administer oath of office till the disqualification is decided. He can say that. Should he say that? Should he not say that? That's an area where your Lordships have never looked at, so to say. Well, obviously, it's premised on constitutional morality. Then, can a constitutional court, in a matter relating to disqualification of the 10th schedule, decide the matter on its own without referring the matter to the Speaker for decision? And if so, under what circumstances? Right? Directly what my Lord put to me, and we are aware of it. If the decision of the Speaker that a member has incurred disqualification under the 10th schedule relates back to the date of the action complained of, then what is the status of proceedings that took place during the pendency of a disqualification petition? Because it relates back, he is the Chief Minister. What do we do? Which is why the time is of the essence. What is the impact of removal of para 3 of the 10th schedule? I've already argued that. In what circumstances will the Speaker recognize the whip and the leader of the political party? I'm arguing that. What is the scope of power of the Commission with respect to determination of a split? That's something I'll argue later. This is, according to me, the issue that your Lordships might wish to look into. Now, let's kindly have a look at my overview document, which is document for the last submissions, petitioner submissions.
A.
A, that's correct. And kindly have a look at outline and over PDF page
5.
5 overview. Well, as your lordship may skip that, I want your lordship straight away to take you to the issue of the whip. Chapter 7. Yes, yes. Of whips and the role of political parties.
Which portion?
This is at PDF page 70.
No, which 5?
Of the written submissions of petitioner, the same document.
Petitioner.
A written submissions A, mothers, of the petitioner. Page 70. I hope to finish today, Mother, so that I don't take too much of your lordship's time.
Did you say it's PDF page?
Page 70.
70.
70.
Sorry. 70. Yes.
Chapter 7. What is the scope and power of the Speaker to determine the whip and the leader of the House? What is the interplay of the same with respect to the provisions of the 10th schedule? Well, let's, the petitioner respectfully submits that the leadership of the original political party is exclusively empowered to determine which member of the House shall be the whip, and also the leader. Lordship, Justice Shah doesn't have.
Yeah, now.
Petitioners respectfully submit that the leadership of the original political party is exclusively empowered to determine which member of the House shall be the whip, and also the leader of the House Legislature Party. The Speaker is bound to recognize the person who had communicated by the leadership of the original political party to be its whip and leader of the House Legislature Party. The Speaker's role in this regard is merely administrative in nature. The Speaker cannot abuse his role to defeat the spirit and intent behind the provisions of the 10th schedule. Now, it is submitted that the respondent's case is hinged on a legal misconception that the whip under paragraph 2(1)b of the 10th schedule can be issued, changed by a majority of the members of the legislative party, which is what they did on the 22nd of June. The defense is in the teeth of the plain reading of 2(1)b, which my lord has already read, Malas. So that's exactly what we were wanting to do. A bare reading of the aforesaid provision would show that the framers of the 10th schedule were conscious that the disqualification was to be incurred for violations of the whip issued by the political party or any person or authority authorized by the political party. There is no reference at all to the legislature party in paragraph 2(1)b of the 10th schedule. This distinction between political party and legislative party is also borne out from a reading of paragraph 1(b) and 1(c) of the 10th schedule, which brings out the difference between the meaning ascribed to the legislative party and the original political party. The respondents in defense have sought to intermingle the definition of political party with that of the legislative party, and have sought to extrapolate the legislative party in the place of a political party into 1(b). It is further submitted that para 1 of the 10th schedule makes a clear distinction between the term legislature party and original political party. The term legislature party is defined as the group consisting of all the members of that house for the time being belonging to that political party. And the term original political party is precisely defined as the political party to which a member belongs. Further, the definition makes it clear that the said term is specifically defined for the purposes of 2(1) of the 10th schedule. In this regard, Kuldeep Nair's case, you'll kindly have a look at paragraph 4. I just quote there. Authorities are certainly not wanting, which indicate that courts should interpret in a broad and generous spirit the document which contains the fundamental law of the land or the basic principles of government. Nevertheless, the rule of plain meaning or literal interpretation described in Maxwell's interpretation of statutes as a primary rule could not be altogether abandoned today in interpreting any document. Indeed, we find Lord Evershed, the length and detail of modern legislation has undoubtedly reinforced the claim of literal construction as the only safe rule. It may be that the great mass of modern legislation, a large part of which consists of statutory rules, makes some departure from the literal rule of interpretation more easily justifiable today than it was in the past. But the next is very important. But the object of interpretation and of construction, which may be broader than interpretation, is to discover the intention of the lawmakers in every case. C. Crawford, the object can obviously be best achieved by first looking at the language and used in the relevant provisions. Other methods of extracting the meaning can be resorted to only if the language used is contradictory, ambiguous, or leads really to absurd results. This is an elementary and basic rule of interpretation as well as of construction processes, which from the point of view of principles applied, coalesce and converge towards the common purpose of both, which is to get at the real sense and meaning. So far as it may be reasonably possible to do this, or what is found there laid down. The provisions whose meaning is under consideration are therefore to be examined before applying any method of construction at all. And 2.1a and 2.1b makes it very clear. Violation of the will and voluntarily giving up membership. And well, as your lordships with experience knows what act amounts to voluntarily giving up membership. We endorse and reiterate the view taken in the above quoted paragraph as a judgment. It may be desirable to give a broad and generous construction to the constitutional provisions, but while doing so, I'll just read this, to the rule of plain meaning or literal interpretation, which remains the primary rule, has also to be kept in mind. In fact, the rule of literal construction is the safe rule unless language used is contradictory, ambiguous, or leads to absurd results. I'll continue after lunch.
We'll come back up.
Yes.